Our Second Amendment right to bear arms was again a big issue in the judge's confirmation hearing today, but she sidestepped questions, predictably, on whether that right applies to states as well as the federal government. As a result, the National Rifle Association today declared it opposes her confirmation as a Supreme Court justice. Bill Tucker reports.
After 222 years, the right to keep and bear arms may turn out to be an acquired right, not a fundamental right, even though many say the guarantee of that right is explicitly stated in the Second Amendment to the U.S. Constitution. It's a school of thought unnerving to gun rights advocates and one senator from Oklahoma in particular.
So what does the law say today about the statement? Where do we stand today about my statement that I claim to have a fundamental, guaranteed, spelled out right under the Constitution that is individual and applies to me, the right to own and bear an arm? Am I right or am I wrong?
Precedent says, as the Second Circuit interpreted the Supreme Court's precedent, that it's not incorporated.
Sotomayor was one of 3 judges on the Second Court panel. In layman's terms, she's saying that the Supreme Court has never ruled that the Second Amendment is a fundamental right, meaning the constitutional guarantee does not apply to the states. A small distinction with profound implications.
What if we had a right to free speech, but it only bound the federal government and that the states could silence you? What if you had a right to assemble, but that would only mean assembling in federal areas, not state areas? What if you had a right to choose, but states could still ban abortion? That's the difference between an individual right and a fundamental right.
Sotomayor did not state her position as to whether or not the Second Amendment is a fundamental right, noting that the Supreme Court will likely take up just that question in the coming months. Many gun owners believe their rights were assured with the decision last year in U.S. versus Heller, where the Supreme Court ruled that the residents of Washington, D.C. do have a right to gun ownership.
But legal scholars say they're wrong because Washington, D.C. is not a state, it's a federal district. Now, the Second Amendment is not the only unincorporated amendment. Neither are the Third, which deals with the quartering of troops in homes, parts of the Fifth, mainly the right to a grand jury, and then the Seventh, promising a jury trial in any case over $20. Luke?
And why would those not be fundamental rights? We all think of the Bill of Rights as fundamental. Right. Why would the Second, the Third, Fifth, and Seventh, or parts of the Fifth, not be fundamental?
Because they're largely procedural and the states have covered those for the most part.
In other words, because that's the way it is.
Yes.
All right. Bill Tucker, thank you very much. We'll see what the Supreme Court decides in the upcoming months. Thank you very much.